All right, welcome back. A few days ago, which was last weekend, Nnamdi Kanu, the leader of the proscribed indigenous people of Biafra, was sentenced to life imprisonment on a 7-count charge, mostly bordering around terrorism. And that has generated a lot of conversation. Well, his legal team say they will definitely appeal that particular case. Well, that's a conversation we're about to have in just a moment with one of his legal counsel, Mr. Aloy Ejimako. Mr. Ejimako, thank you so much for coming on the program.
Good morning. I'm happy to be here with you today.
All right, Mr. Aloy, let's hear your interpretation of what played out in court. We were all witnesses to it, and I know that after the, is it 3 or 4 hours, I read the about 140 or so pages of the CTC that was released almost as soon as possible by the Honorable Judge James Omotosho. And there are different layers I would like to speak to. But let me give you the opportunity to give your own overview of what you make of this case. You've been on it. This is 10 years down the line, in between many things and many courts, all the way to the Supreme Court. I'm back here, and then finally here, giving it the initial closure, perhaps going all the way to the Supreme Court again.
Well, first of all, I have to make it clear that it appeared from 2021 that the deck was stacked against Nnamdi Kanu. The system, the entire system seemed to be against him, against what he was doing or what he was saying. The desperation of the system was evidenced in June 2021 when he was renditioned in breach of all canons of international law and laws of Nigeria and laws of Kenya. That is indicative of the desperation of the system towards him and against what he was doing. The system was intent on really doing him in, whether through any of the means, through any of the instruments that was available to the system. So it came to a head on 20th November, and to a lot of people, it's a surprise. But to those of us who are insiders, we discerned that this case was a very tough case to win. It was very tough, like I said, and it happened that on 20th November it played out. But right now, what we are faced with, or what everybody should be concerned about, is post-judgment, the post-judgment regime. Nnamdi Kanu still retains his constitutional right to fair hearing under Section 36 of the Constitution. That constitutional right is going to be expressed before the Court of Appeal. Or perhaps there could be some post-judgment maneuvers that could be made before the High Court. But for now, it is known, well known to the whole world and to the court, the High Court, and to everybody else who is a stakeholder in this case, that Nnamdi Kanu has no legal counsel. So as I speak, he still represents himself. But see, after the sentencing, I was surprised, and I think everybody else who was monitoring this case was surprised that he was plucked from Abuja and taken all the way to Sokoto, which is in the northernmost part of northwest Nigeria. So you begin to ask, how can he effectively prosecute his appeal, or even take the initial steps towards initiating his appeal? Initiating an appeal is not an easy thing to do. He has to file a notice of appeal, he has to request for the transcripts of the record of proceedings before the High Court, pay for them, review them, and do all sorts of things, all sorts of activities that will now play out before the Court of Appeal. And these things require his personal, physical presence to get these things accomplished, unless he hires a lawyer. And up to this point, he hasn't indicated that he's going to hire any lawyer, or he has not made known to anybody that he has hired any lawyer. So you begin to wonder whether he will be able to prosecute this appeal from his prison location in Sokoto. The Sokoto division of the Court of Appeal doesn't have jurisdiction over this case. It's the Abuja division. So putting him in Sokoto, I know it's true. It is not the fault of the judge. It is the fault of the executive branch. Once someone is sentenced, it becomes the property of the executive branch, in particular the correctional service. So that decision to put him in Sokoto perhaps did not take into account these concerns that I'm expressing. It is very insensitive to his rights. Prisoners do have rights. That you are in prison doesn't mean you have lost your rights under Chapter 4 of Nigerian Constitution, your fundamental rights, in particular Section 36, which is really what is relevant now. Can Nnamdi Kanu effectively prosecute his appeal or even initiate it from that location in Sokoto? The answer is no. So what I think may play out in the coming days or weeks is to seek ways and means of ameliorating the detention conditions. The judge did not particularly order that he be detained in Sokoto. There was only one prison in Nigeria that was excluded, and that was the Kuje prison. But, you know, if you check around Abuja area, the environs, there are other prisons in the vicinity. We have one in Suleja, we have in Kefi, and there are probably other prisons within 2 hours of Abuja. Those prisons would have been much better locations for detaining Mazi Nnamdi Kanu to ensure that he's close enough to his relatives who are known to be in Abuja, his legal consultants if he still wants to deploy their services. Also, is also very close to the Court of Appeal in Abuja, which has jurisdiction over this matter, and so on and so forth. So we're looking at a situation where his right to appeal is being complicated by the current location of his imprisonment.
All right, Mr. Ejimako, a few things I would like you to address, because in this case, apparently will get to appeal, as you've rightly put it. I don't know whether you're going to be his counsel. The choice of being a pro se litigant, I don't know whether you're privy to his reason, and I do not also know whether he's going to canvass new positions, because being a pro se litigant and not entering his defense is as good as saying I'm going into a boxing ring, I'm not going to fight. And he has his reasons, which is what I want to relay. And Section 36 of the Constitution 1999 as amended says that subject as otherwise provided by this Constitution, a person shall not be convicted of a criminal offense unless that offense is defined and penalty thereof is prescribed in a written law. And in this subsection, a written law refers to an act of the National Assembly or law of a state, any other subsidiary legislation, instrument under the provisions of this law. Now, if you go to some of the case laws being cited by even His Lordship, James Omotosho, some of those from the Supreme Court, from the Court of Appeal, you can see perhaps this is where Nnamdi Kanu was holding on to say what, because they charge him based on anti-terrorism law of 2013, which has been appealed. And perhaps some of these case laws he cited from the Court of Appeal and the Supreme Court saying that when a law is repealed, it has no legal life, as far as the courts are concerned. The Honorable Judge cited this. But if you go to Section 98 of the Anti-Terrorism Prohibition Prevention Act of 2022, this is what gave the judge the leeway to be able to prosecute Nnamdi Kanu. If you read this, the Terrorism Prevention Act number 10 is repealed. Any regulation and all of that, I don't want to waste too much time, ongoing cases in court and blah, 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 you can see, and have effect as if made, issued, given, or done under the corresponding provisions of this act. This is the route which Justice James Omotosho passed through to say, let's even agree without conceding that the law is repealed, so we don't have any ground in terms of the pronouncement of the Supreme Court. But there is a proviso in the Anti-Terrorism Act, let me put it that way, Section 98, that says, if we've already started these proceedings before that act was enacted, although the one he was charged with was repealed, there's a provision to continue the trial. Is this something Nnamdi Kanu can be able to beat in court?
let me begin to address this question this way. I'll give you an example. During the military administration, we had the Armed Robbery and Firearms Decree. Under that decree, if you committed armed robbery, you were not taken to the regular courts. You were taken to before a military tribunal. Tried in a summary manner, maybe within 2 or 3 weeks, and in some cases you'll be taken to your village to face the firing squad, or you'll be taken to the bar beach in Lagos to face the firing squad. But when the military administration ended and the civilian administration came in, that law was repealed. But it didn't mean, the repeal didn't mean that commission of armed robbery suddenly no longer became an offense. But you were no longer tried before military tribunals and taken to your village to be executed by firing squad. Your offense will be brought to be in conformity with the current law, which probably it may carry death penalty if you committed armed robbery, but this time it will be by hanging. And the procedure for trying you no longer will be a tribunal procedure empaneled by military officers, but in this case, it will be empaneled by judges, and you'll be tried in the regular courts. I believe this to be the closest analogy to Mazen Nnamdi Kanu's case in chief before Justice Omotosho. He was saying in effect that I'm not saying that the government does not have the right to prefer charges against me or to bring me before this court to try me. But by God Almighty, I should not be tried under a law or provisions of a law that was repealed as far back as 2022. So you have read Section 98. I'm familiar with it. It is arguable whether Mazen Nnamdi Kanu's case was an ongoing case as contemplated under that section that contained the saving clause. You see, there's an argument, which I think is very strong, that Mazen Nnamdi Kanu's case was closed. It ended effectively on 13th October 2022, when by virtue of the discharge by the Court of Appeal. That extinguished that case forever and placed a barrier to bringing the case back under a law that had then, some months before, been repealed. So when the case went to the Supreme Court, and the Supreme Court vacated that judgment of the Court of Appeal, it was left for the government to bring the case in conformity with the current law, but not to proceed with the old. So Mazen Nnamdi Kanu was not saying that my offense has been extinguished by the repeal. He was saying, in effect, that the process or the law that should be applied to my case is the current law. I'll give you another example. When the Administration of Criminal Justice Act was enacted into law in 2015, Nigeria stopped using the Criminal Procedure Code. Nobody went back to Criminal Procedure Code from 2015 onwards till today. Everything that was happening under the Criminal Procedure Code was not automatically extinguished, but all of it was brought into conformity with the current law, which is the Administration of Criminal Justice Act. And I'll give you another example, which is very fundamental. Nigeria used to have a constitution before 1999, and that constitution is called the Constitution of the Federal Republic of Nigeria, 1979. In 1999, Nigeria enacted a new constitution. From that moment in 1999 to the 1979 constitution, that 1999 constitution also contains savings clauses that acts done or purported to be done under the 1999 constitution remain valid. Apply the provisions of the 1970 be done after 1999. So this is the technology that will help our people to understand why Mazen Nnamdi Kanu was insisting that the repealed law should not be law, should not be the law that should regulate the case against him. That was his case in chief. Thank you.
Mr. Jimoko, let me ask you, as his consultant and somebody who has represented him in court before he decided to, defend himself and all of that, do you think that you and the lawyers around yourself who represented Mazi Nnamdi Kanu have failed him and have failed his wife and have failed the Southeast region? His wife, Uchechi, has also come out to criticize you and your colleagues that you didn't brief her that he was transferred to Sokoto. I wonder how you respond to that. And perhaps, what does this imply for the Southeast region, especially with 2027 just along the line?
Let me begin by saying a criticism of the performance of his lawyers, except one dribble that I saw from a disgruntled somebody who probably has a personal score to settle with one of the lawyers, or who has a personal score to settle with Mazi Nnamdi Kanu.
Mr. Jimoko, I think
that will be.
Yes, I think we lost connections with you for a few seconds. Can you go over that information again? And are you referring to his wife there?
Well, I'm saying Nnamdi Kanu was represented before Justice James Omotoshu's court. The defense was led by Chief Kanu Agabi, a former Attorney General of the Federation, and a highly respected lawyer. I don't see anything he might have done that anybody would consider to be incompetent, or that he did not do what he was supposed to do. So under him, all the lawyers did their best. He led the defense team well up until the time that Mazi Nnamdi Kanu decided to go solo and represent himself. But one feature that you must not miss in this case, the prosecution had from March to September to present his case. But when the case changed gear and Mazi Nnamdi Kanu disengaged his lawyers, he was given barely a total number of 13 days to make his case. And if you remove the weekends in those 13 days, he will be 9 to 10 days left for him to make his defense. And he had proposed that he would call to the for him to call his. So this thing, some the made nonsense of that opportunity.
Oh dear. Mr. Jimako, maybe just Mr. Jimako, can you hear us? We're not sure. The network seems to be obstructing the conversation, but we really want to get all.
I can hear you.
Apologies, it's not your fault. It's the network. Because while you were talking, at some point we couldn't hear anything you were saying. If you could just land.
I can hear you.
Yes, no, I know you can hear us, but the network distorted your whatever you were saying, so we couldn't hear you. Maybe you can just wrap up with just land on your thought on that one, on what you were saying. In addition, do you think it's wise for him to continue without a lawyer?
Well, like I said, there was a realization on his part that the deck was stacked against him, so he probably didn't want the lawyers to be the fall guy in the wall, and he wanted to go down fighting. I don't believe 1 million lawyers standing behind Mazi Nnamdi Kanu would have changed the outcome of the case.
Are you saying it was predetermined, or are you saying this justice is not according to law? Is that what you're implying?
No, that's not what I'm implying. I can give you an example of the trial of Jesus Christ. The people that brought Jesus Christ before Pontius Pilate already made up their mind. Even Pontius Pilate offered them to take someone else who also was condemned to death, that they should take that person and go and crucify him. They refused. That they said they wanted Christ. It was Christ they wanted to crucify. So the system already made up its mind that Christ was going to be crucified. I'll give you another example, that of Nelson Mandela in South Africa. Nelson Mandela was not tied to any act of violence in South Africa, but he was convicted anyway. No weapon was found against him, whatever. I think it was his force of personality that constituted enough threat to the state, that the state was convinced about his guilt way ahead of time. And that of Awolowo in the 1960s, Awolowo was convicted of attempt to overthrow the government of Nigeria. Was Awolowo a military officer? He was a civilian. There was no evidence laid in the case of Awolowo, the case of Awolowo, that indicated that he possessed the arms, the means and the opportunity to overthrow the government. But he was convicted, a civilian convicted for overthrowing the government, attempt to overthrow the government. That is absurd. And the judge said it as much. He said that his hands were tied in that case of Awolowo. So in this very case, I'm not saying that the judge is biased or the judge predetermined it, but it was palpable, it was in the air that the system was very determined to see that Mazen Nnamdi Kanu gets convicted. And it didn't start today. It started from the very day he was renditioned in Kenya.
We have to round off our conversation with you now. But when you say this, there are those who say that perhaps you're justifying the killings of over 30,000 Igbos and the killings of police officers who have either been injured or killed as a result of some of the words and instructions or insightful words that perhaps the court would hold on to. Do you think that Mazen Nnamdi Kanu should also take responsibility for some of these things that played out in the Southeast region? I mean, one of your leaders was on our program yesterday, Senator Ojuzo Kalu, and he even questioned the character of Mazen Nnamdi Kanu in courts, for instance. So I wonder perhaps if you think Mazi should take responsibility for some of the actions, some of his actions. And finally, I asked you a question about the possible consequences of this judgment on the Southeast region, because you have been quoted as saying that the ruling party, APC, should forget about getting votes and numbers in the Southeast region. Is that correct?
Well, let me tell you this. It's very unfortunate and highly regrettable, and I feel very sad that lives were lost in Southeast. A lot of lives, innocent lives, the lives of security officers, and so on and so forth. But, my thing is this, that the evidence laid before the court failed to make a connection, a clear connection, a clear nexus between Mazen Nnamdi Kanu broadcast and those the acts of violence or so-called acts of terrorism that occurred in Southeast that led to the loss of lives. It is not insensitive to say it. Anybody that really would not be touched by the lives lost in Southeast or in any other part of Nigeria due to insecurity will be very, very insensitive. But by God Almighty, before we crucify a man for that, or we convict a man for that, we have to draw a clear parallel, a clear connection between what the man said, between what Mazen Nnamdi Kanu said, and the loss of those lives. There is an American adage that says that if the witch cried at night and the baby died in the morning, it doesn't mean that it is the witch that killed the baby. So it is very academic for us to dissect in this case here. The deed is done. I disagree with the conviction. I disagree with the verdict and the sentence. So whatever I'm saying here is a demonstration of my disagreement. But the judge might have found that he had sufficient evidence to back up the decision or the judgment that he rendered. But myself, as a lawyer, I personally did not see that clear connection between Mazen Nnamdi Kanu's broadcast and the violence that occurred in Southeast that claimed a lot of lives. And that violence is still occurring today. Is he still making broadcast?
Mr. Jimako, my apologies, we're totally out of time. So that we are clear, we heard the judge, we heard him read those transcript where he said clearly that Mazi Kanu instigated the people, tell them, go here, kill them, do all the things he said. And indeed, it happened. So how do you absolve him of the deaths when he clearly said those things according to the statement of the judge?
Well, like at the beginning, I said, where do we go from here? We're not going back to the High Court to retry these cases. So we shouldn't be addressing this question in the context of trying to retry a case that has been tried and closed. The question you ask will be a question for the Court of Appeal to answer. So in doing an appeal, Mazi Kanu might be well advised to raise an issue, to raise a question for the Court of Appeal, whether what he had said, for instance, what you said that he said here, whether what he has said rose to the level or raised sufficient weight of evidence to ultimately blame him for the deaths that occurred in Southeast.
All right, Mr. Jimako, totally out of time. It's not what I said, it's what we all listen to the judge. I have the CTC, we all have the CTC. It's a public document now, so it is what the judge used to convict him, connecting what he said to instigate and provoke people to act and lead to the death of military officers and innocent civilians. But that's the question, as I agree with you, the Court of Appeal will have to answer. We must thank you, Aloy Jimako, legal consultant to Mazi Kanu. Thank you, sir, for coming on the program.
Thank you very much.
We'll take a break, and when we come back, we will be talking about governance and national security. Awal Rafsanjani of CISLAC will be joining us in just a moment. Stay with us.